Terrence McNally. Welcome to Free Forum, a world that just might work. And I'm going to be speaking today with American legal scholar Robert Post, a professor at Yale Law School, about the American legal system, free speech, academic freedom in the age of Trump. And you can learn more about Robert's work at law.yale.edu/Robert-C-Post. On Freeform, we explore the lives, the work, the ideas of individuals that I suspect have pieces of the puzzle of a world that just might work. We look at politics, economics, environment, business, science, health, culture, all based on the fact that I believe we can do better, and I want to find out how. The show streams weekly on the Progressive Voices Network on TuneIn. Podcasts are available anytime, anywhere at Apple Podcasts, Spotify, most major podcast sites, and at my site, terrencemcnally.net, TERRENCEMCNALLY, Terrence McNally, all one word, .net. I've long believed that Donald Trump's style in all things and all situations is how much can I get away with? Individual laws may be obstacles to be overcome, but the broader legal system is something to be exploited to his benefit. Can I lie on my financial statements? Can I grab them wherever I want? Can I make business deals from the White House? Can I delay consequences long enough to be reelected? Can I violate the Constitution? Can I defy judges' rulings? Can I serve a third term? What does this, as a prevailing approach to the world and to other human beings, model for a society? How does the law or rules-based society survive within that reality? Someone who was born in the year 2000 has watched that model triumph or at least dominate from the age of 15 to the age of 25, some very formative years. I used to worry that we'd been such poor stewards of democracy that China would end up saving the planet because authoritarianism could respond better to the climate crisis. They could mobilize and pivot more quickly and more decisively than democracy with its lobbying and its back and forth and so on, especially a democracy as hamstrung and distorted as our current form when it comes to solving problems. Events have overtaken that worry. Turns out we were such poor stewards of democracy that authoritarianism now rules here, but without China's concern for the future. We've seen the courts and the judiciary play an outsized role in our politics and our society over the last few years. The Republicans successfully stacking the Supreme Court, with 3 justices appointed by Trump giving them a 6-3 advantage, resulting in the overturning of Roe v. Wade, their immunity ruling on presidential action, and their numerous emergency rulings so far this year, enabling Trump's constitutionally questionable actions to take force while their legal status winds its way through the courts. Today, as I said, I turn to American legal scholar Robert Post to get his take on what's happening, how we got here, how current events fit into the longer picture of American law. Robert Post is a professor at Yale Law School, where he served as dean from 2009 to 2017. He previously taught at UC Berkeley School of Law. In addition to his Doctor of Law degree from Yale, he earned a PhD in the history of American civilization from Harvard. He also clerked for Supreme Court Justice, the late William Brennan. His books include The Taft Court, Making Law for a Divided Nation, Citizens Divided, A Constitutional Theory of Campaign Finance Reform, and For the Common Good, Principles of American Academic Freedom. Welcome, Robert Post, to Free Forum, a world that just might work.
It's a pleasure to be here, Terry.
Great. And let me tell listeners, we're recording this conversation Monday, August 18th. I like listeners to get a feel for the people behind the work and the ideas, the books, whatever that we talk about here. So can you tell us briefly in your words about your path to the work you do today? And feel free to go way back. Childhood inspirations, mentors, turning points, moments of decision. Take it away.
Well, as you know, I grew up in Beverly Hills, California.
And let me just cut in and tell people, the reason Robert said, as you know, is we were classmates and friends in college some 55, 56 years ago at Harvard.
I went to Beverly Hills High School. My father was a movie director, and I grew up in the arts. And then I went to Harvard undergraduate. We were both class of 1969, which is a very famous class at Harvard because it was our class that took over University Hall in the face of Harvard's complicity in the Vietnam War and its encroachments on various neighborhoods throughout the Boston area. And so I grew up in a very politicized environment. I went to graduate school there and in, as you said, history of American civilization. But what I mostly wrote about was literary criticism, the development of the American novel, and how it related to social structure. My work at that time was largely what we would call post-structural. So I would look at the structures in aesthetic form of the novel, but the academic positions were going to people who did something called new criticism, which was closed textual analysis. And it didn't look good for me in the world of American literary criticism. So I decided to go to law school. My father's career was on the decline then, and I thought, well, go become a lawyer, do literary criticism at night, and during the day, do law. And so I went to Yale Law School, which was and is an amazing place, very directed toward a theoretical study of law. The famous statement about Yale Law School is anything you can do, we can do meta. And then I ended up clerking for a judge named David Bazelon, who was at the time the chief judge of the DC Circuit, and then for William J. Brennan on the Supreme Court. And then I went to practice at an Irish litigating firm called Williams and Connolly, where I learned how to be tough, how to be in a courtroom, how to handle witnesses. And my chief client at the time was the Washington Post, the newspaper, defended them in a libel suit from the president of Mobil Oil, William Tavlerius, and his son. It was really quite interesting, fascinating work. And then I went to Berkeley Law School to teach, taught there 20 years. The kind of work that I do is understanding law as if law were a social anthropologist carving out different meanings in our own social life. So every time you see a legal distinction made by a court, what you're actually seeing is the court's understanding that this form of practice is different than that form of practice. So it's a kind of performative social anthropology. That's what law is in the way I think about it. It creates the very categories of social meaning that anthropologists just try to observe, but judges actually make these things happen by their opinions and by their holdings. And I became a specialist in First Amendment law. I write a lot about the development of First Amendment and the regulations of speech. And then in 2003, I went to Yale, and I've continued that work here. I spent a few hard years in law school administration as a dean, but thankfully I'm out of that now and get to think again and write again in my own voice. The hardest thing about being a dean is that you lose your personal voice.
Wow. I wouldn't have thought of that. I would have thought the hardest thing is that you got to get into fundraising or something like that. But you lose your personal voice because you when you speak, you are speaking as a law school.
I'm speaking for the law school, as the law school, so it's very hard to be who you are. Everything you say has to be calculated in terms of how it would impact a school. And you get your voice taken away from you. It's like the Little Mermaid.
Yeah. And you do it willingly and you do it consciously, but you do it constantly.
Constantly.
Yeah. And to you, I can see that would make that would be well,
Like,
I didn't even mean it that way, but no, you've carved a personal journey here and so on. This approach that you take to law, which is as you say, sort of as real-time social anthropology. How common is that?
it's very uncommon. Most people in my profession want to see the law as a set of rules. They want the judge not to be making law, but to be following law. And of course, that's impossible. We all know that that's impossible. When John Roberts gets up and says, we're just umpires, we call them by the pre-existing rules, everybody knows that's nonsense. Judges have to comply with something we call the rule of law, but the rule of law is quite different than just following a rule. The rule of law is not, contra Antonin Scalia, the law of rules. The rule of law is following the practices of previous courts and understanding how they can be reasonably projected into the future and respecting the reliance interests of people who have depended upon past precedents. That gives you lots and lots of room to maneuver. One of the best analogies for the rule of law was given by a great jurisprudential thinker named Ronald Dworkin. He said the law is like a chain novel. You know, one judge gets to write the first chapter and the next judge writes the second chapter. So you've got a lot of room to maneuver, but it has to be the second chapter that follows the first. And if it doesn't follow the first, then the novel doesn't make any sense.
A lot has been made, I think, very, very sensibly about this current Supreme Court and their not only not just calling balls and strikes, but actually overturning precedent. I know they've done it in some gun laws. They've done it in Roe v. Wade, most famously, and so on. Speak just a little bit about that, given what you've just said. That means their Chapter 20 is not following Chapter 17.
That's correct. They're making a large turn in the course of the law, and that's not necessarily a fatal mistake. I mean, that's what the Warren Court did.
I was going to say, yes,
That's
in
what
our
so
day.
infuriated critics of Earl Warren is that he overturned Plessy versus Ferguson, which, you know, was a 100-year-old precedent. Not 100 years, 80, 90-year-old precedent. So great courts can do that. And then you judge them on the quality of the law they make. That's one criterion. Does it make sense what they're doing? And the way a lawyer thinks about an issue is if you can decide case A this way, then you're going to have to decide case B that way. And do you want a world in which case B is decided that way? That's a criterion in which you assess what a court is doing. And this court rather deeply fails that criterion. So I'll give you a simple example in an area that I know well, which is the First Amendment. So this court has been notorious for extending First Amendment, which say freedom of speech protections, to commercial speech. So setting aside ordinary social and economic regulations because the court says it's contrary to somebody's freedom of speech. And if you step back for a minute, you can see that virtually everything you do is speech. When you sign a contract, you're doing speech. When you're giving a product warning, you're doing speech. So when a lawyer gives advice, it's speech. So if everything is speech, then everything is protected by the First Amendment. Everything is constitutionalized. That plainly can't be true.
Right.
And so the court is making holdings that cannot be correct, that you cannot believe what they're saying. The court has held, for example, that every time the state engages in viewpoint discrimination or content discrimination, it says you can say this but not that. It's subject to what's called strict scrutiny, meaning it's presumptively unconstitutional. And that applies to commercial speech as well as to ordinary speech. So if the court really meant that, then the Federal Trade Commission would go out of business. It couldn't be regulating advertisements for being misleading. Does the court really mean to say that commercial advertisements which are misleading can't be regulated? I don't think so. And yet they give this very broad, abstract pronouncements, which can be followed or not followed at will by courts below. And what that is an invitation to follow your ideological proclivities quite apart from the rule that was seemingly announced, because it's not a serious rule. It's not meant to be taken seriously. It couldn't be taken seriously. And that's the sign of a court that is changing precedents, but in a bad way, in a thoughtless way. And that's very characteristic of the Roberts Court.
Wow. And the thing that I had noticed over the years is reinterpreting freedom of religion to give greater freedom to what I claim is the expression of my religion than your civil rights. Um, right? Can you talk about that? Because I think I described it correctly, but fill in the picture there, because that's one
Well,
they've done more than once.
the difference between freedom of speech and freedom of religion is freedom of speech gives you the freedom to talk in ways that freedom of speech recognizes. So it doesn't apply in the same way to lawyers' advice or contracts, right? We have a definition of what counts as speech for purposes of freedom of speech. Freedom of religion applies to actions. So I'm free to act in a way um, dictated by my religion, and the state can't prevent me unless the state meets a high burden of proof. And so that's called the free exercise right. That's also a First Amendment right, the right for the free exercise of my religion. And the
Those
court,
words are right in that First Amendment.
it's both, it's in the First Amendment. And the court has been, this is a court driven by, let's say, the religious revival of the right. But this was caused by something really amazing in American history. Throughout most of American history, American Catholics and American evangelical Protestants were at each other's throat. They hated each other. They were at war. American evangelicals were deeply anti-Catholic. And what caused them to come together was Richard Nixon's attack on Democrats and his appeal, his efforts to get the Republican Party to appeal to working class Democratic Catholic voters. And abortion was a big thing like that. So evangelicals were never anti-abortion
I know.
um, or Roe versus Wade. And Nixon takes advantage of that and he allies it with being anti um, drug, and he puts that into the culture wars. And suddenly there's a rapprochement between American evangelicals and American Catholics, which happens in the late 1970s and 80s. And this creates this pro-religion, qua-religion movement on the right. And this court is the full flower of that. And again, they take positions which make no sense at all. They take positions that a private corporation can't be forced to act in ways contrary to the religious beliefs of the owner of the private corporation, case called Hobby Lobby. And that means they can't be required to provide insurance that would cover abortion to their
Employees.
work. Now, the interesting thing about that case is the owner in Hobby Lobby is a Protestant, and there is no Protestant doctrine of complicity. But the lawyers representing the owner of Hobby Lobby were Catholic. They were the Becket Foundation. And Catholicism does have a doctrine called complicity, which means I can't be forced to be complicit in your sin. So they claim this is the religious violation of the Hobby Lobby owner's rights when it's not a Protestant doctrine at all. The court opinion is by Alito, who's a Catholic, and he just sets forth this doctrine of complicity as though it applied to the religious beliefs of the Hobby Lobby person, which it doesn't.
And
In
probably to a lay listener, one assumes that applies to all religions.
correct, and of course it doesn't. So that's an example of this a broad tendency to conflate any culture war's religious position as everybody's religious position. A second issue is they're going to say it's a bona fide religious claim if you say that it is. And we will not use the court to question the authenticity of your claim, the sincerity of your claim. Well, that means anytime I want to be exempted from a law, I can say, well, I have a religious belief, and the court says they will not second guess my religious claim. That can't be right. And yet the court repeatedly says that.
For instance, when I would read in the paper or online, who reads the paper, right? I would say, what? And that was all the people who claimed religious exemptions from mask rules or other rules during the pandemic.
Well, there's a famous there's a case about a group of nuns. I think they're called Sisters of Mercy, but I'm not sure. which said it was a violation of their religious beliefs to sign the form to say that they were exempt. It was absolutely an absurd claim.
Wow.
Yeah.
Yeah.
A case I taught was, I think it was the University of Massachusetts, and they had a mask rules during COVID, and a kid wanted a religious exemption from it, and he was Catholic, and the school said, no, you don't get it because the Pope has said it's appropriate to take precautions. So as a Catholic, you can't make that claim. He goes to court, and the court says, well, this is your authentic religious belief, even though you're Catholic and even the Pope says something else. So what does that mean?
As you say, it really means I can, at the extreme, I can commit any crime and claim that the reason I committed it was an
Right.
expression of my religious
It's
beliefs.
my religious belief that Trump is the Messiah, so I get to vote 3 times. Really?
Right, right. One of the things I wanted to point out is a film that does a great job, I think, of the story of the right and the evangelicals and so on. Is a film called Bad Faith, which is basically a history of that movement in great detail and in great chronology. But one of the things it points out that goes back to the point you were making was that it was 4 years between Roe v. Wade and the moral majority coming out against abortion.
The Southern Baptist Conference took a position in favor of therapeutic abortions.
Yeah. And the reason I was pointing out this 4-year lag is that what happened to stimulate their change of position was not Roe v. Wade. It was their recruitment to the Republican Party.
It was Pat Buchanan who made this an issue for Nixon's campaign.
Yeah. And one other thing that we don't want to miss, although many people probably know it, is having said what we've said about Catholics, that there are 6 Catholics on this Supreme Court. I was brought up Catholic, and we were there was certainly a message even at that point. So we know I went to college in '65, so we're talking, the early '60s, to look down on Protestants. There, Jews may have killed Christ, but the Protestants were that much better off. When John Kennedy ran for president, he had to go a long way to distance himself from his Catholicism, from the Vatican, and so on. And now we have 6 Catholic justices. Speak to that for just a moment.
Well, there's nothing wrong with 6 Catholic justices, but there's something wrong with 6 Catholic justices who put their Catholicism first. And it's something very close to that is happening on the court. And that's what makes it bad.
Okay, let me switch just a little bit here. What role does teaching law play for you? How did you choose that path, and how critical is it to you in your work in the law?
Well, there's a relationship between what I teach and what I write. So, for example, I teach a course with my wife, who is a woman named Reva Siegel, who's a professor of law at Yale Law School also. And we have developed a way of thinking about constitutional law called democratic constitutionalism. It's a way of understanding the law politics distinction and the way to understand how social mobilization transmutes itself into law. And we developed that out of teaching a course called Democratic Constitutionalism. And mainly we studied right-wing mobilizations and how they were so successful in changing constitutional law. And you get a theory of how law works when you look at it from that point of view.
You kind of reverse engineer what happened.
Well, you watch it descriptively and anthropologically, and then you see how it works. So we have an article called Roe Rage, which is about the backlash to Roe, which was the first article actually to point out that it wasn't it's not a backlash to Roe. It's a backlash that was created by the partisan Republican Party using it as a partisan issue. And we wrote that, I don't know, 20 years ago, and that created this point that you just made. And it allows you to make many observations like that about how law actually functions. And we continue to teach that. We just started on polarization with the question of, can you have law if society is sufficiently polarized, which is a deep issue for us now.
What is the purpose of law? And you sort of went into it when you said what you did at the top, but what is the purpose of law, and what is the role of enforcement?
Law has different functions in different kinds of societies, but if you look at a complex modern society like us, where people have to deal all the time with strangers, right? If you're a small tribe of Aboriginals in Australia, you don't need our kind of law because interactions are face to face. People share common norms and just common customs, and so they know what to expect of each other and of the people they have to deal with. But in our society, if you're walking down the street, you don't know half the people you see. You have to know what to expect from them. So law entrenches the norms and rules by which we deal with each other, meaning mostly deal with strangers. And you can't, it turns out, live your life unless you take certain things for granted. You're not going to be killed. Your property is your property. No one is going to tell you, when to get up in the morning and what to eat, et cetera, et cetera. So when you think about the kind of life you want to lead, law is our way of ordering society such that it contains the values and achieves the purposes that you want your life to do. So law is the instrument by which we order society to attain the values that we want to attain. That's the basic function of law. And you asked about
I asked about enforcement.
enforcement.
How is it related to the law? At this point, just to put a very timely notion on it, we see Trump doing things which lower courts are saying are unconstitutional, but then it becomes, where does enforcement come in? The other
Right.
thing I would say is that what we watched prior to the 2024 election was that one could work the legal system with delays and so on, in which enforcement never takes place. So, what is the role of enforcement, and how
Great
do
question.
lawyers think about it, and how does the law, how does it fit into this whole picture of the law?
Okay, so um, if you think about ordinary social norms, you're supposed to act in a way that is respectful of people around you. If you walk into a party and you start screaming and acting in inappropriate ways, how do we enforce the norms of propriety? We do it because people shun you, people act to you in ways you find unpleasant. That's enforcement for social norms. But if I'm dealing with strangers, I'm not going to see those consequences because I'm not going to see how they're behaving toward me. And so what we do is we bring the force of the state to bear to enforce the law. So law channels the organized force of the state. And we say, if you're going to go through red lights, you're going to have to pay a fine and you're going to have to go to jail. And we have different ways of enforcing different kinds of norms. So in some, we bring the force of criminal law to bear, which is the most stringent form of enforcement that involves social stigma, it involves deprivation of liberties, it involves fines. Then we have forms of civil enforcement, we call those torts or administrative regulation. So the means of enforcement are calibrated to the importance of the standards which are being enforced and how well we want them to be enforced. If you look at a market, let's take that as the paradigmatic side of law. So you buy goods and you don't want to be defrauded. You go pump gas. The pump tells you you've got 3 gallons. You want it to be 3 gallons, not 1 gallon. Or it says it's $3 a gallon. You're not being charged $5 a gallon or whatever. You have to trust that. And if it turns out that that's cheating you, that's a very bad thing in the market. So weights and measures, all sorts of things about if I'm going to order something in the mail, it really should arrive or I should be able to get my money back, that sort of thing. We couldn't have a market work unless people were abiding by common standards, which allow us to relate to each other with some degree of confidence. Now, when people try to theorize that in law now, and I emphasize now, they tend to put economic modeling behind it. They sort of say, which standards will produce maximum efficiency? And
And you're
they
saying that
calibrate,
that very question is an economic, is in the realm of
they imagine
economics.
it as an economic question. And by making it an economic question, they make it an issue of individuals calibrating uh, whether it is more costly to violate the norm or to comply with the norm.
Mm-hmm.
There is a doctrine in law in contrast called efficient breach. I will breach your contract if it's efficient to do so.
And
And
this
we,
is that whole thing that happens where we see that corporations can be fined for certain illegal practices, but you will often hear people say, given their annual volume and profits, this penalty is just a cost of doing business.
it's the same way you would regard a parking meter fine. Is it
Oh,
more convenient to pay the parking meter fine if you just have to run in and out of store, take the risk of
right.
being caught against the
Depends if
amount of the
I'm
fine?
late or not, right? It's that kind of
Right.
decision. Yeah.
You make these calculations all the time, and there's many areas of life where we do. And if you think about law from that perspective, it follows what Oliver Wendell Holmes called the bad man theory of law. That is to say, the law is what the bad man calculates he can't get away with. You set the incentives such that the bad man can't get away with it.
So you make
And you,
you make law with the bad man in mind, rather than
yes,
rather than Fred Milk with toast, right?
exactly so. And that's the way in which you construct market rules very much now, and many kinds of rules like parking meter rules, um, where we don't put a moral freight on what the rules are. We just need the rules enforced. Now, um, when you get an actual bad man,
Okay, I'll tell you what. I know where we're going with that because I've got a question to set that up. So let me take a moment to tell people what they're listening to, and then I'll throw it back to you with the question about now. This is Freeform, a world that just might work. I'm Terrence McNally. I'm speaking with American legal scholar Robert Post. He's a professor at Yale Law School, where he served as dean from 2009 to 2017. He's written several landmark books about the American legal system. And we're talking about that system, about free speech, about academic freedom, and about the current atmosphere that law is needing to contend with. And you can learn more at law.yale.edu/Robert-C-Post. Okay. First of all, I remember learning that the rule of law was a fairly essential prerequisite for business and industry when people are thinking about whether to invest in a third world country. How well have they established the rule of law? Is it predictable? Is it safe, etc.? And then I look at the current situation right now, and as I said in the intro, my contention is that Trump's relentless attacks on norms, rules, and laws, his how much can I get away with? It seems to me, learned at the foot probably of Roy Cohn, that is his basis in all spheres. I mean, you'll see people that do it in one sphere and not another. It just seems like it's his approach. What can I get away with? And then I look at that, and as I said, a young, let's say, young male who has seen that attitude ride the center of society since they were 15. They're now 25. What is that going to do about their approach to morality, ethics, law, and so on? And so I'm worried not just about the results in Trump's cases, though they are frightening, but also about the influence on culture and morality.
right, so I was going to say, when you actually have someone in the market who's acting like a bad man, and this describes the way Trump was as a real estate developer, he would break contracts and say, come sue me. Water rises to its own level. You go bankrupt, people don't want to deal with you because you get a bad reputation. The
So that's
market
that
has
social that's that social censure thing.
exactly so, because people actually don't want to deal with bad people. And in the market, with repeat players, you begin to bear the cost of that. And Trump did. He has brought that same market attitude to the way in which he's being president. He is acting in ways that are blatantly illegal and then saying, come stop me if you can. So he is a bad man who's a president who's saying to the courts, come stop me. And the point here is that when we use law to bind the president and sort of say what government should and shouldn't do, we do not have a market in mind. We don't have a bad man in mind. This is a different functioning of law. law functions sometimes to govern interactions like a market, but it often functions to embody the values of a society, which we expect people to internalize and to enact. We don't expect them to be a bad person. We expect them to internalize the values, say, of non-discrimination, which the law is setting before us, and to act ethically according to the norms that the law is trying to. That's the law that binds the executive. And so what we have here is a category error by Trump,
Right.
showing us that you cannot act like a bad market actor and be president, because then the whole system collapses.
And so this distinction that you're making, you said category error. I know you have said that the the meaning of the law, the interpretation of the law, is somewhat determined by the social situation in which it takes place, by the social practices that it regulates, and so on. You pointed out that in the market, we do go by the bad man thing. We make rules, people push them, and then the law settles that push, and maybe the line gets moved in one way or the other, and so on. But that's in the market where it's expected. You are trying to make as much money as possible without violating the law or being put out of business. But you were pointing out that there are other sectors of society than the market where laws apply and it's different. I think it's a big hallmark of the way you look at things is these different structures, and you got to change hats or change lenses or something when you move from one to the other.
In law, we make a distinction, for example, between what we call a malum in se and a malum prohibitum. So a malum in se is something that's bad in itself. Don't murder. That's a norm. And we expect people to understand that it's a bad thing. A mala prohibitum is something that's prohibited because we need some systemic effects. And it's not bad in itself. That's like a parking meter. It's not morally bad to get a parking ticket. It's a mala prohibitum. And so we calibrate the fines in a parking meter with the understanding that people are not going to internalize that norm. But we don't expect people to act in the same way with respect to murder, right? So laws carry different functions depending on the kind of law that they are. And the laws governing the executive go to the morality of government. They don't go to mala prohibita.
So and you say that's regarding the president, that's regarding basically anyone that we've entrusted
With that power.
that power. And so I mean, it's that whole thing of when they swear on the Bible and that I will uphold the Constitution. They
Correct.
are making the point that I have the power, but I have just vowed before God and so on to moderate that power.
To take care that the laws be faithfully executed. That's how we imagine the laws binding the executive to be. And Trump is in flagrant violation of all of that, as is, his joke of an attorney general, Pam Bondi. And this is a fundamental betrayal of the way public law should work in this country.
Right. Okay, I'm going to switch gears a little bit, although it's still going to apply here. Using the concept of rules and laws fairly interchangeably. And I had a question, is there a continuum? Norms, rules, regulations, laws, and so on. In which case that continuum used to include norms, and now it sort of doesn't. They don't have any resemblance to laws anymore in the view of the administration and so on. But I'll set that one aside. But using rules and laws fairly interchangeably, two people that I've interviewed, equality-focused economist Branko Milanovic and Harvard Business School professor Rebecca Henderson, in separate conversations, both said capitalism is not, on the face of it, the problem. The way that capitalism works does seem to harness energy and produce often good and blah, blah, blah. But when capitalism goes wrong, when capitalism is corrupted, is when it sets its own rules. And it's my contention that certainly with Citizens United, and ever since, we now see very clearly that that it is setting its own rules. Milanovic even makes the point that China is now a capitalist state, only it's state capitalism. And there's some sense that with Trump wanting a cut of chip makers, that we're turning into, people thought, we integrate China into the world system, they'll become more like us. And it's turned out it's,
Well, think about Amtrak if you want a better example.
yeah. So FDR was able to save capitalism from itself when it hit the crisis of the Great Depression. He was elected and took the actions, I say, at a point before where we are now. In other words, his bold platform forestalled authoritarianism in America. There was a Rachel Maddow has that book and podcast series and everything about America in the 30s and how it could have gone either way. We actually have gotten to a point where we do have authoritarianism in the US. And the Democrats, it seems to me, failed to save capitalism from itself while all this inequality was growing that fed the environment for Trump. Clinton didn't do it during the tech bubble. Obama didn't do it after the crash. Biden began to do it. If one looked at the actual policies, he was speaking to the people who ended up electing Trump in 2024, but couldn't communicate it. So people didn't know what happened. You, I believe, are a fan of the power of public opinion in democracy. But when Musk can spend $270 million, what's happened to the meaning of public opinion? Can you respond to that whole train of thought about saving capitalism from itself or not, and where we stand?
Well, the first thing I would say is I don't like to give agency to abstract concepts like capitalism. Capitalism doesn't do anything. We do something. So if it's gone off the rails, it's because we have gone off the rails. And now the question is, in what sense have we gone off the rails? And one way to understand that question is, what is the relationship between the political sphere and the sphere of the market? We can conceptualize the market and we can conceptualize politics. If market controls politics, then we're all going to be subject increasingly to market rules and market disadvantages. And that can be a very terrible thing because the market imagines people in the way we described before.
That's right. It goes back to that distinction we were making just before.
Yes. And the political is an area in which we, first person plural, decide what we want to do. How self-conscious is the political? How independent is the political from the market? These are the conceptual questions that one has to ask. And this is a continuum. And in decisions like Citizens United, the Supreme Court has taken many steps to constitutionalize the control of the market over the political. It's because of decisions like Citizens United that Musk can spend $250 million to control the outcome of an election, which means that market inequalities are going to translate themselves into inequalities of political power. And that's a very bad thing. Because we should control the market, we should have that form of economic relationships that we politically want, not that the wealthy or those who have succeeded in the market want to impose on us.
Ideally, the market takes place within
the
political and the social and the moral.
Correct.
Rather than everything else taking place within a market point of view.
Correct. That's what we have to understand. So, you mentioned I wrote a book on the Taft Court. The Taft Court is known for the revival of Lochnerism. Lochner is a case decided by the Supreme Court in the first decade of the 20th century, in which they said that the state cannot control the market because there are independent property rights which limit what the state can do. So the court in that case found that a law which said that you couldn't impose more than a 10-hour day on bakers was unconstitutional because it limited what it called freedom of contract. Freedom of contract is meaning I can do whatever I want in the market. So the market would control the political. And that's because property rights were conceived to be limiting on what the state could do. And the Taft Court was the zenith of Lochnerization, where the court would say, for example, you can't impose price controls because the price has to be set by the market, not by the state. And the New Deal revolution in constitutional law was that no, the political controls the market, not the market, the political. And that was the great change that happened in American constitutional law in the 1930s. And what we're witnessing now is a very conservative court, which is re-Lochnerizing many things. And it's using, for example, the First Amendment. When I said before about Lochnerizing First Amendment and commercial speech, that's an example of that.
Yeah, the whole cake issue to a gay person and so on. That's mixing this up. So, can you take a step back, something that's underneath everything we're talking about here in terms of the market ruling? It seems to me is it really ends up impacting trust, and whether we have trust or not, whether we experience trust or not, impacts everything else. But it seems to me when you begin to run everything in society according to market, that erodes trust. Speak to the issue of trust, which I think is perhaps the resource we most are in need of at this point.
Yeah, well, if you think about the markets, we said before, the law conceptualized it as interactions between strangers who don't trust each other. And so conceptualized according to this bad man theory. And it turns out if you live your life in the market, you live a pretty alienated life. And you don't end up trusting people. The more your model of dealing with other people is a market model, the less trust there's going to be, point one. Point two, the more losers there's going to be because the market tends to be very strong in sorting winners and losers. And people resent it when they're losers. They live a very hard life. The nation state is a form of solidarity that's not market. It's the opposite of market, in which we have to identify with each other, in which we support each other because we're, in the famous phrase of Benedict Anderson, we're an imagined community,
right,
where we have face-to-face obligations. So the nation state has a very different form of solidarity than the market. And I get angry and I want to use the nation state to enforce my form of solidarity if I'm losing continuously in the market. That's a form of populism that you see with Trump, for example. Everybody's got to be me because now I'm going to stand for the nation state, and I'm really angry. I don't trust people who differ from me.
Can you talk a bit about the thing that I've seen so unnerving, really, to me, and disheartening, is the Supreme Court allowing the administration to put into practice actions that have been found by a lower court to be unconstitutional. And while the decision is winding its way through the courts as to whether or not it is unconstitutional, rather than leaving the status quo in place in case it turns out it was unconstitutional, they are allowing people to be fired, grants to be stopped, research to be broken in half, et cetera, while we await these decisions. They could have gone the other way. And at one point, this Supreme Court ruled 15 for 15 on emergency rulings, giving Trump the right to put into practice things that were under contention. And just how they're approaching that and what the meaning of that is.
Well, there's different takes on what's going on with the court doing that. One take, a very powerful take, is that this is a court that's infatuated with something called the unitary executive theory. This is the theory that the president has strong inherent powers, that the president should be and was meant constitutionally to be the strongest branch of government, the one which was the leader, which can, bend laws to his will. John Roberts cut his teeth on that theory when he was a young lawyer in the Meese Justice Department. Kavanaugh did too. So the idea of a unitary executive means that a lot of the things that we thought the executive was bound by, laws and things like that, He's actually not. So these rulings about temporary injunctions and suspending the injunction reflects the court's substantive view about the limits of executive power, which is the executive now becomes more like a king, much more independent of law and of the courts. That's one view. And there's a certain amount of truth to that, a great amount of truth to that. But there's also another view, which is this is a guy who is deadly to play ball with. He Trump does not lay down in defeat. He declares war on those that frustrate him. And it's plainly the case that there's going to come a time when the court's going to have to rule against him, and they have limited resources of legitimacy.
Going back to enforcement, right?
That goes to enforcement. And so they're conserving their legitimacy for the cases they think are most important or when they have to do it. This question of enforcement, very famous statement by Andrew Jackson. It's attributed to Andrew Jackson. He, put the Cherokee on the Trail of Tears, and John Marshall said that was unconstitutional. And Jackson says, Marshall has made his ruling, now let him enforce it. And when I teach constitutional law, one of the first things I teach the students is law, which is the force of the state, is inseparable from its enforcement. So the question I ask them is, why, when the South fired on Fort Sumter, why didn't Lincoln go to the Supreme Court and ask for an injunction against the South seceding? Why didn't he do that? Because it would have been a useless act.
Yes.
You can say you're enforcing it, but enforcement doesn't happen merely because the court says it.
Right.
Enforcement happens because the judgment of the court is itself respected, or those people who have to enforce it obey the court. And if they don't, then the court can say whatever it wants, and there's no such thing as enforcement.
Yeah. One thought that I've had is that if they assume, this is one way that I think they justify what they're doing, which has had enormous harms, the things that they've let him do while under contention, is that they assume that ultimately it will come to the Supreme Court, and ultimately we're going to vote his way anyway, and so why not? That's another
take. Yeah, that's the substantive take, that they're cluing us into the substantive law. And for many of those stays, that was undoubtedly true. But for many of them, I don't think it's so true. And so you need a different kind of explanation. And I think this court is scared.
Scared of that confrontation. And
scared because, once you say that the emperor has no clothes, what's the enforcement power of the court?
Right. Okay. It's a power.
So if you're a justice, you have to manipulate that power in a very subtle kind of set of ways.
And Trump has shown you how he's going to do his side. So you have to play that game. Okay. Let me, for the kind of last question, you have done a lot of work on First Amendment, on free speech, and on academic freedom. The contrast, the distinctions between free speech and academic freedom, and what that means for what's going on college campuses today.
So the simplest way to think about that question, suppose you have a young astronomer who wants tenure in the astronomy department, and he writes this book. It's a very provocative book, and he says, the moon is made of blue cheese. And he publishes that as an editorial in the New York Times, and he puts that as his manuscript for tenure. Okay? Freedom of speech says the state cannot punish him, even for saying something totally wrong and outrageous in the New York Times. But academic freedom says, yeah, this is terrible astronomy, therefore he doesn't get tenure. So academic freedom is the kind of freedom necessary when an institution actually wants to expand knowledge and teach students to think for themselves. And that requires all kinds of judgments about speech. If you think about student speech, we compel speech, we give students examinations, we engage in viewpoint discrimination, we give certain views A's and certain views C's, and we flunk other views, right? We teach you how to discriminate between good ideas and bad ideas. The basic principle of freedom of speech is that the state can't do any of those things. So when I have freedom of speech, when I'm speaking to public opinion, and trying to determine what the opinion of the country should be, not the knowledge, but the opinion. The state cannot intervene to set my agenda. It can't tell me to talk about one thing versus another. It can't tell me which are the good views or the bad views. It can't compel me to speak. It can't do any of those things. But when you're in school, the university tells professors and students all of those things because it's there to teach you how to think better. And it's there to make better knowledge. Now, you need certain kinds of freedoms to do that. But you also need certain kinds of evaluation. So we have a totally different structure because the function of the freedom is very different.
Right. It's interesting to me how often your responses come back to these: what realm is it in? What world is it taking place? And clearly what you're saying there is that the purpose of a university is different from the purpose of a society, and is different in the purpose of a government, and all of those
Right.
things, and that the development of knowledge depends on criteria, and things like tenure depend on criteria, and it's a different world.
Precisely the case.
Wow. Okay, this has been really enlightening, Robert. I hope that people, when they sit down to listen to this, go, okay. What I mean is sort of it's a little big picture and upstream of what people are usually thinking about when they're reading today's headline and getting today's take. And I really appreciate that's what I turn to you for, and I think that's what we've given people. So again, Robert is a professor at Yale Law School. His books include Citizens Divided, For the Common Good, The Taft Court. He has writings on academic freedom and free speech. So the big issues that have been taking center stage during Robert's career, he's written about most of them. And actually, one of the things that we didn't get into, Robert, is that you have sat on those committees and those boards and so on that have actually helped the law profession decide the meanings of some of these things. And that to me was quite a revelation. I went, of course, there are people who have to do that, and you're one of them. For this conversation and many other interviews and articles to join me in pursuit of a world that just might work, go to TerrenceMcNally.net, TerrenceMcNally, Terrence McNally, one word, .net, or a world that just might work.com. They're the same website. If you want to get my weekly email newsletter telling you who's going to be on, what we're going to talk about, and links to probably 10 or 15 relevant, timely articles, email me at TEMcNally, TEMCNALLY, @mac.com. You can sign up at my site or at most podcast sites to get the podcast. The archives, which you will find at my site or at most of those sites as well, go back 400, 500. I've been doing this for 25 years. Michael Lewis, Naomi Klein, Robert Reich, Van Jones, Bill McKibben, etc. You can follow me on Twitter at McNally Terrence, and we'll change to Blue Sky soon. I just haven't done it yet. Thanks to Kiana Williams in production, George Vasilopoulos at Progressive Voices, and most of all, you, my listeners, please share this podcast widely. And finally, Robert Post, thank you and keep up your good work.
Thank you so much, Terry. It was a real pleasure, as always.